Hi, my name is Bojorquez, and I welcome you to this training brought to you by City Hall Essentials. Today we'll be talking about open government, which is one of my favorite topics. I gave my very first presentation on this topic back in 1997 when I was a brand new young lawyer working for the Texas Municipal League. And every year since, I've done some of these training sessions, and I'm always learning something new, whether it's from my clients or a change in the legislation, a court case, or an AG opinion has come out. So even if you've heard some version of this training before, I hope you'll find this interesting and learn something new that will make you more effective. When I talk about open government, we're going to break that out into two pieces today. The agenda will have first the Texas Open Meetings Act, and then after that, the Texas Public Information Act. Before you get into the details of the laws, what they require, what you're obligated to do, I think it's really important to grasp a major concept first. As far back as the 1970s, we here in Texas have made the policy choice that in order for citizens to actively participate in their government, they must have two things. First of all, they must have access to the data upon which government leaders are using to make decisions. And the second thing they gotta have is access to the decision-making process. It's not enough in a democracy for citizens to just be told what their government is doing or what we've done. They have a right to understand how we got to that point and what choices we're considering and why we do the things we do. And in order to effectuate that level of citizen engagement, we here in Texas have the Texas Public Information Act and the Texas Open Meetings Act. And those are the two things that I'm going to walk you through today. Now, I've been training long enough to enough citizens and enough elected officials and staff to know that when it comes to adult education and training, no matter how intently you pay attention and no matter how interesting I try to be, as soon as this is over, you're going to forget about 90% of what I've taught you. But I'm determined that there's going to be at least 6 things that I touch on that you will remember and you will own those forever. So first of all, you will have an easier time in government service if you just assume that all of the data you come into contact with is public, which means we have a duty to hold on to it and we have a duty to share it with anybody who asks. Now, there are going to be some exceptions and I'll walk you through that. But if you'll just sort of orient yourself to that assumption, I think you'll have an easier time. Another thing that I think will make your career much better in public service, whether you're a volunteer, an elected official, or staff, is if you think before you create. We are creating so much data these days: email, text messages, video, audio, and we're doing it at lightning speed, often without really thinking about the content that we are memorializing and not really considering the lifespan. How long will these digital blips last and who gets access to them? And so if you think about that and some of the things that I'll touch on in this training session, hopefully it'll change the way you create data. Maybe you don't want to send that impulsive text message. It's better if it's an email. Maybe an email is not really appropriate given the gravity of the situation. You should write a memo. Maybe memorializing your thoughts in writing isn't the best thing after all. You need to have an actual face-to-face conversation with someone. And so if you'll go through that split-second analysis, I think you'll save yourself some grief and you'll better serve the city or local government that you've signed up to work for. One thing I want you to remember very carefully is this third prong. Private devices can have public information. Here's my cell phone. I pay for it. I pay for the service. I pretty much am the only person who has access to it. But yet I could be walking around with a treasure trove of public data in my pocket. And the Open Meetings Act, the Open Records Act is going to apply to that device no matter who paid for it. And so if you think broadly about your laptops, about your iPads and those sorts of things, it helps you control what you create, what you store, and what you might have a duty to give other people. I run the risk of annoying you today when I say beware of email. And by email, I really mean electronic communications, text messages, social media posts, different messaging platforms, maybe internal to your organization or external. Because under the law, it doesn't really matter what platform you're using. If you're conducting city business, that's probably covered by the Public Information Act, which means you have a duty to disclose it to people upon request. And so before you hit send on something that perhaps you wrote in a hurry or you were emotional at the time you composed it, you might want to hit pause and come back and look at it later, or have someone proofread it before you hit send. Because when it comes to protecting the legal position of your cities, towns, and villages, we can be very, very vulnerable by what's in the emails that we send. Assume that all gatherings of your board, your committee, your commission is a meeting, which means it's covered by the Open Meetings Act, and the public has a right to come watch, listen, and perhaps speak. Now, maybe your group isn't covered by the Open Meetings Act, or maybe there's an exception that allows you to have a discreet conversation behind closed doors. But if you just assume that whatever board or committee you're serving on is covered, that's going to make it less painful for you. And then you can look a little bit deeper to see if there's an exception or an exclusion that might apply. And then finally, be careful about walking quorums, often referred to as a daisy chain. When groups of less than a quorum communicate about public business, but it adds up to a quorum and can be a criminal violation of the Open Meetings Act. And I'll explain the details of how that is under our statute. So think about those 6 things going into the presentation, and then we'll check back on them toward the end. So I'm a lawyer, a municipal attorney, and a professional trainer. I'm happy to be doing this because City Hall Essentials asked me to. One of my favorite topics to cover with clients and with audiences. Why are you here? Why did you find this video worth accessing? Well, if you're newly elected, it's required that you undergo this training within 90 days of taking office. That's a statutory requirement, and the training that we're presenting today has been approved by the Office of the Attorney General of Texas as satisfying the statutory requirement. So you're good to go. Even if you've taken it before, if you've since been reelected, you got to go through the training again. What's another reason for going through this video? It's just a good idea. The things that I'm going to cover is going to affect most of you most of the time. And even if you think you're an expert on open meetings or open records, I bet you might pick up something from this video that you hadn't heard before. And I'll try my best to give you those tidbits of new data. And you might just learn something that you like having in your tool belt, a bit of knowledge you can use to help your boss, to help your board or commission, to help the local government that you've signed on to serve. And that'll be my goal in this video, is to give you that information so you're empowered to serve better. Where are we going to start? I think we'll just start at open meetings and the Open Meetings Act. Well, normally when you're looking at a statute to see if perhaps the law curtails your behavior, you look to see, what does the law apply to? Well, the Open Meetings Act applies to meetings. Pretty intuitive, right? But do we all know what a meeting really is? Don't worry, under the statute, it's defined. And in the statute, I break it down to about these 5 points. A meeting is a deliberation. Someone's talking. It can be verbal, it can be in writing. It's a quorum, which usually means 51%, but the amount of a quorum is going to vary depending on which board or commission. So it's a quorum of a governmental body talking. Governmental body is clearly a city council, a county commissioner's court, a school board of trustees. It can also be things like your planning and zoning commission, your zoning board of adjustment. You have to look at the actual duties of the board or commission, look at how it's created, and is there a statute governing it? That will help you decide if the Open Meetings Act covers it. But if you've got a governmental body for where there's a quorum talking about something, and that something is a matter of public business, and that item of public business is under their jurisdiction, those 5 points add up to being a meeting. So think hypothetically the entire city council of your town can get together. It's Sunday, it's weekend, maybe it's a Friday night, and they all get together at the local movie theater, but they forgot to put up an agenda. They're not letting the public speak. They're not even keeping minutes. Has the entire city council violated the Open Meetings Act? Of course not. There's no talking during movies, right? So number one doesn't apply. It's only quiet shh in movies. And so they can get together and go to a movie as long as they're not talking, more particularly as long as they're not talking about public business. Another point that I like to bring up is I think that one of my city councils that I serve, they can get together, the entire city council, maybe gather at the mayor's house some weekend, and all they talk about is the Dallas Cowboys. I grew up a Dallas Cowboy fan. My dad never missed a single game, even when they were just broadcast on radio. Unless your city council has jurisdiction over the Dallas Cowboys, they can get together and talk about sports all they want to, because the only thing the Open Meetings Act is concerned about is public business. So if your city council, your board of adjustment, your planning and zoning commission can get together and talk about the holidays, talk about the weather, talk about your local high school volleyball team, they can do that without worrying about punishment under the Open Meetings Act, as long as they stay away from talking about city business. It's that discussion of city business by a quorum of a governmental body that's going to trigger application of the statute. So you have the Open Meetings Act, you know it applies to meetings, you know that it applies to governmental bodies. It requires that any action taken by the city council comply with the Open Meetings Act, which means that a quorum was present and the requirements of the statute are met. And we will discuss toward the end of this segment what some of the penalties are for not doing that. It has long been our history in Texas, even longer than the Open Meetings Act has been around, that cities act through their city councils, and city councils act at meetings. And for there to be a meeting, you've got to have a quorum. So if you don't have those ingredients, then you don't have anything covered by the statute, except for some of the provisions regarding things such as walking quorum, which we will talk about. Now, if you're having a purely social gathering, I mentioned the sports conversation, I mentioned a movie, maybe it is a fundraiser for a nearby nonprofit in town, the statute specifically exempts purely social functions. The statute also exempts regional training functions. So if your council of governments or somebody else is conducting training for the cities and local governments in your area, the entire board, the entire city council can attend that without worrying about complying with the Open Meetings Act. If a group is a purely advisory board that has no power to take action, no power to bind the city in contract, then the statute exempts it. But you got to be cautious, because these days it's gotten quite common for city councils to require boards and commissions, task forces, working groups to comply with the Open Meetings Act, even if state law doesn't require that they do so. Why? Maybe that's one way to keep from stepping across the line legally. Another reason, more and more cities and local governments are pledging themselves to be more transparent, to be more active, engaging the citizens. So making a park and recreation board, making a planning board, making a library advisory board subject to the statute, even when legally it may not be required, that has become very common. So if you're unsure, look at the ordinance or resolution creating your board or commission, and that might give you the answer. And then finally, staff meetings are exempt from the statute. So you can have your city manager get together with all your department heads and talk about serious city business, upcoming agenda items, contracts, ordinances, resolutions, proclamations, and the public does not have a right to go into those meetings. Perhaps you choose to open the doors. Well, that's a local policy decision, and you can make that choice if you want to. But people can't force themselves into those staff meetings. Local journalists can't insist on attending those local staff meetings because they have no right under the Open Meetings Act. So the Open Meetings Act applies to your board or commission. You feel pretty confident about that. Now you know you have to conduct your meetings in compliance with that statute. What's that going to involve? Well, really, there's 4 things. You have to have an agenda telling people what you're going to talk about, when you're going to meet, who's going to be there. You have to have a quorum. So normally that's 51%, but I don't know, with your zoning board of adjustment, for example, it takes a 75% majority. If you are a type A general law city having a special meeting, something other than your regular meeting, well, then you have to have 4 of the 5 aldermen present to do that. So sometimes the amount of a quorum will change, and you want to make sure that you check on that before you start your meeting. Next, the Open Meetings Act is going to require that you have minutes, that you memorialize when did the meeting start, who was there, what items did you address, what action was taken. And then finally, the statute requires public access. The citizens have a right to come to your meetings to watch and to hear what you have to say and to speak on any open session agenda item. Now, there are some exceptions for closed door executive sessions. We'll touch on that. But even if you're invoking one of those justifications, you still have to first convene in open session to do that and let the public know what you're doing. Now, a question that comes up often is, what are the locational requirements for your meeting? Where must you hold it? Must you hold it at City Hall? No. In fact, some of you in small town Texas, you don't have a city hall with room enough to have a public meeting. Maybe you've got a very nice city hall with offices, but you don't have ADA accessible restrooms and parking and those sorts of things. So you can choose to have it at a different building. Is it the Civic Center? Is it the library? It changes town to town. Must you hold your meetings inside the city limits? That certainly makes sense. Or in the county. Well, some of you are split by more than one county. The only real locational restriction under the Texas Open Meetings Act is the state of Texas. You have to be somewhere within our state borders to conduct your meetings. So if you choose to stray out of it for a workshop or a retreat or a training session, you're allowed to do that, but you have to always let the public know where that's going to be. One thing which I will touch on multiple ways in this video to help you thoroughly understand it is you must be cautious about taking action outside of a properly posted, properly conducted public meeting. What am I talking about? Well, there are times when city councils come to an understanding of what their decision is going to be, and they do that some way other than sitting at the dais with everyone watching and listening during a proper meeting. And one example I give is from a city in South Central Texas that once had a city council member get elected and from the get-go made a proclamation. I understand that every year during the budget cycle, we do grants to certain nonprofits in town that are providing public services that perhaps we could have provided this service or held this event, but instead we're contracting to them to do it for us. But there's this one particular nonprofit that I'm not a fan of. I don't support them. I don't support giving them public funds. So when it comes time to make that decision, I am not going to be in favor of giving them that budget allocation. Well, the city council member from that South Central Texas town didn't just say it out loud. He got pen and paper and he memorialized that in writing on a piece of city letterhead and passed it around. Next thing you know, council member after council member signed on to the same letter. And eventually, when the budget was approved and grants were awarded, that particular nonprofit did not get the funding that they had historically received. So did they just take it on the chin and move on and, I don't know, start having car washes and bake sales for fundraisers? No, they sued the city, claiming a violation of the Open Meetings Act, forcefully asserting that the city council came to a decision by a majority without conducting a proper meeting, discussing and voting in public. The trial court agreed with them, and ultimately so did the Court of Appeals. So permanent injunction against that city, plus they had to pay the other side's legal fees and court costs. And so when you think about that city and how they went about the task of physically passing around a piece of paper, old school signing it with pen, Now go that next step and imagine the same scenario, but with email. Hitting reply to all, I agree, same with me, I'm with you. Or even better, imagine that city council member posted his position on the upcoming budget vote on a social media platform like Facebook or Nextdoor. And then council member after council member likes that social media post so that you can see on your screen how they're going to vote. And later you can see the results of their action. But the action never actually took place in a public meeting where they took that position. That can be a problem. And a bigger problem is not just hunting down a piece of paper anymore. When you do that on social media, text messages, email, there's a digital paper trail that can last pretty much forever and be used at your prosecution. It can be accessed by your enemies who want to bring you down or are frustrated with your organization. So please use extra cautious to avoid coming to a consensus and making decisions unless you're doing so at a properly posted public meeting. And that's why I warn you to be careful about email and text and social media. It is so convenient, it's so fast, it's so inexpensive. We're all using it all the time, but in doing so, we're creating these digital records that can be used against us. And if we're actually violating the law, consciously or unconsciously, then perhaps it can be used against us in a courtroom setting, which is perhaps somewhere that we all want to avoid. And so if your group is going to make a decision, make sure that decision is made at a properly conducted public meeting. I've touched on agendas. Now it's time to do a deep dive. What is an agenda? It's really not magical. Who, what, where, when? Who's getting together? What are they going to talk about? Where are they going to be? When do they convene? If you can answer those questions on a piece of paper, then you're going to be okay with your agenda. But there's 1,200 cities in Texas, which means there's 1,200 different ways of doing things. And each of you have your own style, your own form, your own template for how your agendas look and how they're put together. And perhaps when you came to your city, you just assumed that the way it was being done was prescribed by law. Now you may look into it a little bit more deeply and you find out, no, it's a local tradition, a local custom, and maybe there's ways to improve your agendas just a little bit. One thing the law does require of agendas is a level of specificity. How much? It's the reasonable person standard. A reasonable person should be able to read your agenda and know what you're going to talk about. But if the words you choose are so vague and general that a reasonable person would have no idea, that's going to be inadequate. And most people in your town probably won't bother to show up to the meeting, to listen, or to speak, because they don't know what you're going to be addressing. And that violates one of the key purposes of the Open Meetings Act. So if you have agenda item number 4, personnel matters, I got no idea. I don't know, should I eat dinner late? Should I get a babysitter? Should I turn off the TV and turn on my computer to watch a live stream of your meeting? I don't know what personnel matters means. Personnel matters, police chief. All right, I guess I know who you're talking about, but I really don't understand. Did the chief win an award? Well, they got a new accreditation. Maybe the department is now a certified law enforcement agency. Or what? Is this a disciplinary matter? You're considering firing the chief of police? I recommend you go ahead and put a little more meat on the bone. Tell the citizens that you are evaluating the performance of your chief of police and considering options for further employment. Something like that lets them know that if they care about the chief, they hate him, they love her, whatever the issue may be, they may want to show up to the meeting, call you in advance, watch the meeting on video, whatever you do. You need to provide specificity. Now, you do not have to list every possible action that might be taken under that item. If the issue is public safety, the fire department, acquisition of a fire truck, you don't have to go on the agenda and list that you're going to lease purchase, borrow, buy it. Maybe you don't know until you get to the meeting what action you're going to take. There's some discovery and some learning that go on at public meetings. But for those who truly do care about the fire department and the need to have a tanker truck or a ladder truck, you need to put that on the agenda so they know to show up and pay attention. Now, as I travel the state helping cities, I often see agendas that I didn't help write, and they'll have things on them like city manager report, city council comments. Well, under the statute, as long as all they're reporting on or commenting on are general civic events, social functions, hey, there's a pancake breakfast down at the Lions Club on Saturday, or hey, we're lighting the big Christmas tree on the town square, please come enjoy the walk of lights, then it's okay that all the item said was council comments, city manager report. But if they're going into any depth about any particular policy choice, contract, regulation, they need to go ahead and list that out on the agenda. There was an example once here in Central Texas where it was a county commissioner did county commissioner comments. That doesn't tell me much. And when the meeting actually came around, the county commissioner stood up and talked for over an hour about transportation, infrastructure planning. When is a highway going to become a toll road? Did I mention the bridges for the toll road are in an area where the golden cheek warbler has habitat? So now we're talking about endangered species. And so the environmentalists, the special interest groups who care very much about the aquifer and wildlife habitat didn't bother showing up to that county commissioners court meeting because they didn't know they should. There was nothing on the agenda of interest to them. But they care very much about transportation planning and how much that disturbs the wildlife when you build bridges and 4-lane divided highways. And so they sued the county, claiming if the county commissioner had truly said on the agenda what his topic was going to be, they would have been there to pay attention and perhaps comment. But because they were clueless, they stayed home, and that violated the Open Meetings Act. They sued, they won, there was an appeal, they prevailed. Permanent injunction against the county having such items on their agenda, and the county had to pay court costs and legal fees. I'm quite sure none of you budgeted this last summer to put aside money to pay a special interest group's legal fees when they sue you for violating the Open Meetings Act. So I urge you to kind of get away from those generic council report items, or if you're going to use that as a heading, include some subheadings under there. And if you're unsure, have a conversation with your city attorney. Now, I've mentioned executive sessions a couple times, and we'll go into that a little bit deeper later on. But when you're talking about the agenda, you do not have to specifically call out executive session on your agenda. You have the right to adjourn into a closed door meeting, an executive session, whenever you need to, if you have a justification. And for most towns, there's only 6 justifications, and I'll list those for you shortly. But I've seen many cities these days will specifically tell the public in advance that they're going into executive session on items 12, 13, 14, 15. You're allowed to do that. You have the discretion to give the public advance notice, but you're not required to do so. Why would you? Maybe you want the public to know you're only going to talk about something in executive session, so there's no need for them to show up to the meeting. Okay, well, you must honor that if so. But one thing is, it is my position, and I regularly advocate and advise for my clients, that the city council, planning and zoning, whomever, they reserve the right to go into executive session at any point in a meeting on any agenda item if it's covered by one of the justifications. And so what the Attorney General's office says is if you routinely differentiate between the open and closed parts of your meetings on your agenda, to abruptly depart from that might be interpreted as denying the public notice. How do I avoid that? I recommend all my clients put on the bottom of your agenda that you do reserve the right to go into executive session on any item. Some citizens may not read your entire agenda, they miss the fine point at the bottom, and they'll complain later if you just call a timeout in the middle of your meeting to go in on an item that looked like it was open, but now you're going to talk about it behind closed doors. Well, in those instances, you probably should just take a moment to educate the public and let them know that you're allowed to do that, and you're opting to do so because it's in the best interest of the city to get legal advice or to have this conversation with your city manager. One key part of the Open Meetings Act regarding agendas that trip people up regularly is the fact that it's got to be posted 72 hours in advance. Your physical agenda, or if you have an electronic bulletin board, those items have to be up at least 72 continuous hours before your meeting starts. If you don't, because the window got broken, it fell off, the tape came off, someone forgot to put it up, then you're usually not allowed to have your meeting. We'll talk about emergency meetings later, but those are a very rare exception. Your agenda has to be up 72 hours in advance, and it must also be on your website. It used to be all you do is put up a notice of the meeting. Now the full-blown agenda has to be on your website, both of them for 72 continuous hours. Now, if you've had problems with your information technology, some sort of issue with your internet service provider, and there was a blip and it wasn't online for 72 hours, you can still proceed with the meeting as long as the hard copy or the bulletin board copy was posted. But for the most part, you need to do both of those things at least 72 hours. If a topic is not on the agenda 72 hours in advance, that topic is off limits for you unless it meets the definition of an emergency item, which is a very small subset of agenda items. Talked about the agenda, now we talk about the minutes. What's the minutes? It's just agendas with answers. The same who, what, where, when questions that the agenda sought to put out there, the minutes come in afterwards and fill in the blanks. Who was present? Where were you? When did the meeting start? What action did you take? You record all actions and all votes. You do not have to record every single utterance. You can list the people who spoke at the meeting. Are they for or are they against? But the law does not require that minutes be a verbatim transcript as though some court stenographer is just sitting there typing away. But yet many of you do that, and that's okay, but that's a local policy choice. That is a custom or practice, a tradition that you've had. And I've had city council members say, Alan, I don't want to go to every planning and zoning meeting, so I want there to be careful minutes, so if something comes up, I can go back and pull the minutes and take a look. Okay, well these days so many of those meetings are video recorded. I don't know that having someone type up that level of detail is a good use of your resources, but it's not my call, it's your decision. And you're allowed to have paper minutes or a recording or both. That is your choice. What else is required under the Open Meetings Act? I told you about citizen participation. And what's interesting and somewhat new about this is that for the history of the statute, for most of the time I've been practicing law, all the Open Meetings Act required is that citizens be allowed to watch the city council deliberate and listen to them deliberate. Interestingly, for the most part, citizens never had a right to speak. Unless it was a public hearing required by other law, citizens had to sit there and be quiet under state law. So if you're adopting a budget, well, there's a requirement for a public hearing. You're approving a tax, gotta have a public hearing. Maybe someone has requested you rezone their piece of property. Well, public hearing is required. So why have y'all been having citizen comments, public comment period, whatever you choose to call it? Again, that's just a local choice. That's just something you chose to do because perhaps it's the right thing to give citizens that opportunity to voice their concerns, usually about things that are not on your agenda. Well, now the law's changed, and now citizens have a right to speak at your meetings on any open session agenda item, either before you get to it or when you call it up. Why is this an issue? At some point, apparently there were some governments that would have citizen comment periods, and they would restrict all citizen remarks to the very end of the agenda, which often was taking place at midnight. And that's just ridiculous. That's abusive, that's bad governance. I've never been in favor of that and have never counseled or advised the city to do that. But some were, so now we have this new law, which says the moment you open up your meeting, you have a citizen comment period, whatever you call it, public remarks, citizens can stand up and speak, and they can speak about an agenda item, even if it's agenda item number 27. Now you could ask them, are you able to wait until we get to item 27? It'll be fresh, it'll be more relevant to us. And they can say, nope, I'm going to speak my mind on item 27 and then I'm going to go home. The law allows that, therefore you must provide for that. Now you can have reasonable rules. The Open Meetings Act allows you to do certain things such as have people fill out a comment card, sign up on a list, tell you what item they plan to speak on. If you want to follow up with them, you can ask for their address, phone number, email address. I don't think that you can require them to give it to you, but you can ask for it, and that might be a useful piece of information. You can have rules that require them to limit their comments to a period of time, 3 minutes, 5 minutes. You can address whether multiple people can sign up and then pool their time together by donating it. You can have rules about things like signs. I've got signs. Vote no on item 4. Well, maybe your rules say, sure, you can have signs. That's First Amendment protected speech, but we're going to maintain some honor and some decorum and just basic visibility in our room. So those of you waving signs must sit on the back row. Those of you with video cameras, you're allowed to videotape meetings. You're allowed to audio tape meetings under the law, but you don't have a right to sit on the front row. So maybe we make you sit on the side so you're not obstructing people's views or intimidating them with the proximity of that camera lens or that microphone. So as long as you adopt those rules and apply them uniformly, and you're not picking and choosing who's subjected to the rules, you're not invoking the rules just to discriminate against someone because you don't like the content of what they're saying, those reasonable rules are likely to be held up if you ever have any sort of a challenge. The statute says you must facilitate input, so rather than being hostile or aggressive or put off by citizen comments, we must welcome it. And we also must welcome just a little bit of criticism. I have had city council meetings where I have attended and they've had local rules, or the presiding officer, the mayor will say, hey, we're not going to take any of that criticism. Hey, you can't insult our staff. Hey, don't talk about individual people. I understand why they came up with those rules. I don't think you can do that. I think you have to let people insult the city attorney, me, or insult the mayor or the city manager. Now, does that mean you have to let them curse and use foul language, obscene language? I don't know. I think you can ask them to please avoid that language. And if they persist, then you can probably cut their time off. And if they insist, well, then maybe you have law enforcement escort them out of the room. I say I think so because I don't have a clear case where I can point you to. I don't have a clear statute that says so. And one of the difficulties with trying to censor speech these days, because it's obscene or vulgar, is that is so subjective, and community standards are changing. What used to be offensive isn't so offensive anymore. Now, I still think we shouldn't be cursing during city council meetings. Sometimes you've got Boy Scouts and Girl Scouts sitting on the front row because they have to get that merit badge. You have classrooms watching city council meetings as part of their curriculum. It's just not the way to behave in public. I don't like it. I discourage it. And I support my mayors and presiding officers who try to maintain decorum in the room. But how heavy-handed you are is going to depend on how severe the language is. And I urge you in a democratic entity to just be a little bit more tolerant than perhaps you would have been 10 or 20 years ago. Now, when it comes to meeting dynamics, you have regular meetings under the statute, which is meetings that occur at about the same time, same date, same place, over and over again. The statute refers to special meetings. What makes a meeting special? Nothing. It's just another meeting. It's happening at a time, date, place outside of your normal routine. Special meetings must be treated like any other meeting with the exact same rigor and exact same mandates. Often I will see cities that have workshops, work sessions, town hall meetings, retreats, planning sessions. That all sounds great. That signals to me that it's not the normal routine, not the normal structure of a meeting. Often a work session, a workshop, is going to have fewer topics. It's going to be less formal. Perhaps they expect less testimony, only invited comments. maybe no decisions will be made. Is that the way it is in your town? Perhaps. What you got to know is the Open Meetings Act doesn't care. Those extra meetings that you're having to talk about your comprehensive plan or budget preparation for the upcoming budget season, those are just another meeting under the statute. So you have to have an agenda posted, you have to let the public come, and you have to keep minutes of what went on. And so maybe you don't wear a suit and tie during your work session or your planning session. Maybe you're all eating breakfast tacos that you normally wouldn't do during a meeting. I get it, and I support you having those sorts of things. Citizens still have a right to show up, and now they have a right to speak. And for some of you, that's very new. That's not the way you've been doing things. I get it. I understand. The legislature changed the law for us. Now, I mentioned joint meetings from time to time, in part because they happen and you need to know it's allowed and it's okay. But mainly I bring it up because I just think it's a good idea. As a career practitioner of municipal law, I like joint meetings. I like it when once a year planning and zoning and the council get together. Or once a year, the Economic Development Corporation Board of Directors gets together with the city council. They talk about their shared goals, their plans. Is there any tension that we need to resolve so we can achieve that oh so valuable sense of alignment with each other? I've had city councils get together with river authorities or county commissioners' courts when they have a project, a contract in common, rather than use emissaries going back and forth to negotiate new rules. They just have a joint meeting. Perfectly acceptable under the statute. But you both have to put up an agenda and you both have to keep minutes of your meeting. The procedural rules are left to you. How does an agenda get put together? I don't know. Who's the final authority on what the agenda is? I can't really tell you. The Open Meetings Act doesn't say so. And the courts and the Attorney General have never offered an opinion. So again, with 1,200 different cities in Texas, there's 1,200 different ways of doing things. Do you have a local ordinance, a local policy? If you're home rule, does your charter say all items must be turned into the city secretary, approved by the city manager, and the agenda signed by the mayor? If so, follow your local rules. If not, look into putting together your local procedures and what you're going to do and how those things show up on the agenda. I have seen cities that say to get on the agenda, the item must be sponsored by the mayor or the city manager or the city attorney or 2 city council members. Okay, that's reasonable, because if you can't get another council member to sign off on your item, when you pull up the item during the meeting and the mayor calls for a second, there's no second. No second, no discussion. No discussion, no action, move on to the next item. Now, if you choose to have parliamentary rules like Robert's Rules of Order or Rosenberg's rules, that's a local choice, and you can choose to follow those, adopt them, modify them. State law does not address procedural rules at all. And having sat through many meetings, and sometimes my clients have meetings without me, but they call me the next day, I want to tell you a little bit about ratification. Ratification is when you subsequently have a meeting in part, or maybe solely, to fix a mistake you made at a previous meeting. We can have ratifications here in Texas. The Open Meetings Act doesn't address it, but let's say you were going to terminate the fire chief and you didn't put enough detail on the agenda to warrant doing so. So you fired that person, and now you're concerned that they're going to sue for wrongful termination and throw in a violation of the Open Meetings Act for good measure. No problem. You post a new agenda with more specificity this time so that a reasonable person understands what you're going to do. You convene the meeting, you call up the item, you discuss it, you vote. The fire chief is now fired. You have ratified the mistake from the week before. But here's the catch. During that week, your fire chief was still an employee, which means they get all the pay and benefits that they were entitled to. That's kind of cumbersome, right? Can you imagine how awkward that is? I've been through that exact scenario before. So it's important to know that while ratification is an option, It's better just to get it right to begin with. Just go through the details of getting your agenda properly prepared and sticking to your agenda so you don't have to come up afterwards and try a do-over. Executive session has been mentioned several times in this presentation. A lot of confusion about it. I've actually met mayors and city council members who don't like executive session. They think you're trying to hide something from the public. As a guy who serves City Hall, I like executive session. I think it's a very useful tool, and therefore I work really hard not to abuse it and make sure clients are honoring the details of the law regarding this particular tool. Start off by remembering that all deliberations, which is talking and voting, must take place in open session where the public can view and listen. But if you need to go behind closed doors and have that discreet conversation, then you need to first announce in open session what agenda item or items you're going to be talking about, and then you have to cite the number of the exception that allows you to go behind closed doors. Now, that announcement is the duty of the presiding officer, which if it's the city council, it's the mayor, or it's the mayor pro tem in the mayor's absence. But you have to convene the meeting first and then announce which items you're going behind closed door about and what the justification is. You can exclude people from executive session if they don't have a right to be in there or if they have a conflict. Who has a right to be in executive session? The city council. Or if you are the library board, then the library board. Now, usually city staff goes in there. Who's your staff liaison? Is there a clerk or a secretary? The attorney for the entity can go behind closed doors with them. But that's it. You can't pick and choose which citizens. You can't pick and choose which developer. You can't pick and choose which reporter. I've had clients want to go behind closed doors to negotiate an economic development deal or negotiate a land developed construction land use deal. Not possible. Those other groups' interests are not aligned with the city. You might be friends, it might be a friendly contract, but they are still a separate party to that transaction, and only the city officials, staff, consultants, volunteers can go into that executive session, and only to the extent they are necessary for that conversation. So there are times when I'm in executive session, I've got the mayor, city council, usually the city manager, maybe the city secretary. Every city varies just a little bit. If you need the city secretary, your municipal clerk, to keep the minutes of executive session, well, then maybe you want that person there. And then I'll have the Parks and Recreation Director come in because we're deliberating buying new property for a park, and then they leave. And then we have the Chief of Police come in because they want to talk to us about an employment dispute with one of their officers, and the council needs to be aware that perhaps this is going to be tricky when we terminate this officer. Fine. After that, the Chief of Police can leave, and maybe we need to have our consultant come in who has been evaluating our options to build a new convention center, and we need to buy new land for the convention center, and we have a contract with somebody to rent out some additional property. Well, that consultant who's working for us is allowed to come behind closed doors on that item, and then they are dismissed. But what about the council member who has sued your city? Can they go behind closed doors into executive session to talk about the lawsuit with litigation counsel? No, that's an easy one. What if you have an ethics complaint pending against one of your city council members and you have it on your agenda to discuss the ethics complaint? Can you have that same council member behind closed doors? That makes no sense. I think you can exclude that person. But I can't point to you to a court case or an attorney general opinion that says so. So I recommend that before you exclude someone like that, have a tough conversation with your city attorney about their interpretation of the statute and what advice they're willing to give you, ideally in writing. There's a lot of myths and misnomers out there about executive session, one of which is that everything that's said or read in executive session is confidential. And that's not always true. In fact, there's absolutely nothing in the Open Meetings Act that says conversations in executive session are confidential. There's an AG opinion that says that there's no AG opinion and nothing in the statute that makes it confidential. and yet most of us assume that it is. Well, I'd say if you're getting legal advice from your lawyer behind closed doors, yeah, that's privileged, which means it's confidential under Texas law. But if you're discussing how much you're willing to sell a piece of city property for, is that confidential? Well, perhaps if it's labeled confidential on the documents you see, or you're told that it's confidential, or you've got a local rule that makes it confidential, then perhaps it is. But not everything that's said and done behind closed doors is strictly confidential. My advice to you, treat it like it's confidential. Respect the sanctity of executive session. It's a great tool for people to be open and honest with each other without worrying about their neighbors or political blowback for what they're about to say. And I think sometimes governing bodies need to have that open, honest dialogue and exchange, and doing it in executive session helps. But then don't walk out of executive session and blab to the nearest reporter. Don't go home that night and disclose executive session on social media. That's a bad idea. That will create a sense of distrust and alienate your colleagues at City Hall, which is going to make it difficult for you to be effective. But I don't know that every single thing is confidential under state law. Because of that, many cities have adopted their own local ethics codes that says disclosing of what is said or shown or read in executive session without permission from the board, committee, or council is a violation of the code of ethics. Now you're subject to a complaint being filed against you for which there may be civil penalties or a reprimand or just a whole lot of embarrassment. So I'm really urging y'all to be cautious with what is said and exchanged in executive session and try to protect it, because I think it's good for the city, the local government you work for, to do so. Now, the actual minutes of executive session are in fact confidential by statute. There's only one set of minutes, that's the official minutes. Normally it's a piece of paper, it's called the certified agenda. We usually refer to it as minutes, that says when did it start, what items did you discuss, who was there, what action did you take, when did it adjourn? Well, on the issue of action, that's easy because there is no action taken in executive session. All final action must take place out loud, in open, in a properly posted public meeting. So, with all of that, what are the 6 most common justifications for executive session that are available to most cities? Consultation with attorney, deliberation regarding buying or selling or leasing real estate, gifts, whether or not to accept a donation. I've had cities that have received millions of dollars in land being donated for parks and whatnot. How about personnel? Hiring, firing, promoting, transferring officers and employees. So by officers and employees, I don't think the legislature meant just your staff. I think it covers other council members or perhaps members of your planning and zoning commission. I think they are also officers of the city. Another justification is security measures. Security measures regarding the video cameras, whether or not your dais is bulletproof or resistant. What is the evacuation procedure if a bomb threat is called in? What are you expected to do if there's an active shooter? Those are things you can talk about behind closed doors. And then finally, economic development. Are you considering giving incentives to a business to come to your town, stay in your town, expand in your town? Well, if discussing that out loud might blow the transaction, you can discuss it in executive session. And so when you look at your slides, you'll see at the bottom I've listed off the legal citations that cover all those exceptions. If the presiding officer wants to go behind closed doors to talk to me about something on the agenda, they must say, hey, at this point, we're going to adjourn into executive session to talk to our lawyer about item number 17. And we're going to do that pursuant to Texas Government Code 551.071. To make it easy for your presiding officer, you may want to give them a little cheat sheet to have there at their place right next to their gavel and microphone. Or many of my clients just list the possibilities on the agenda itself. So the mayor or the presiding officer, or the chairperson can just scan through the agenda, find it, and read it out loud. But if you don't tell the public what items you're going to be discussing and what justification allows you to do it, then you can't do it. And nothing is more awkward than having some local lawyer criticize you in writing or turn you into the AG's office, the Attorney General's office, because you had an illegal executive session. You've got video conferencing that just a few years ago, no one knew how to use it. They were uncomfortable using it. They were downright resistant to using it. Well, we've had the law on the books for many years, allowing telephone conferences and then eventually video conferences. But until the pandemic, most of my clients were reluctant to utilize that technology. But when it became unlawful for us all to gather in large groups and it just became unsafe and unwise, many of us quickly figured out that technology. And during the pandemic, the governor issued some executive orders that made it even easier for all of our counties and schools and cities and municipal utility districts to have online meetings. But now all those orders have been rescinded or expired, and so we're back to business as usual under the Open Meetings Act. We can still have open or closed sessions online. The legislature tweaked the rules regarding telephone conferences. You can still have them, but only if there's an emergency, which is an imminent threat to public health, safety, and welfare that was not reasonably foreseeable. You still have to have a quorum gathered in person, and the person on the phone is not allowed to vote. So phone calls have kind of fallen out of favor in my experience. What I'm seeing a lot of these days are video conferences, web meetings. And you can have video conferences at any time as long as you comply with the rest of the rules regarding posting your agenda 72 hours in advance. There are some special rules for web meetings, and basically they are this. The presiding officer, such as the mayor, must be at a location where the public is allowed to come live and in person. A quorum of the body must be physically together in the same location. You can't have them scattered across the nation just participating by video. You might be able to have one or two, but a quorum still has to show up somewhere where they can be together. And you must have two-way audio-visual technology so that everyone who's speaking can see and hear everyone who's speaking, which often means a lot of screens and a lot of microphones. If you can't pull off the technical requirements, then you can't have that person participating by remote. The requirements regarding allowing citizens to participate by remote have expired. And so if you're choosing to keep doing that, that is a local policy choice. One thing that I've seen creep up from time to time is allowing citizens to email their comments into the city and have someone at City Hall read them out loud during a city council meeting. If you're still doing that, I suggest you sit down and talk to your attorney about the wisdom of that decision. I've advised all of my clients to stop it. If someone wants to email instead of coming to the meeting, perfectly okay. Maybe we make copies of those messages and hand them out to the council before the meeting or put them at their place at the dais. But to have one of my clients, a city employee or elected official, reading somebody else's words out loud into the record, which is going to be recorded, it may be broadcast live on the internet, that's just got too much risk in it. Particularly when there's so many people these days just being hateful and disrespectful. I don't want to hear their words coming out of my clients' mouths. So I hope that you stop doing that, or if you're going to persist, you're doing so with the guidance of your city attorney. But one thing you have to remember about meetings, I told you you could have a recording of your meeting and that be the minutes of the meeting, but you're not required to record your meetings unless it's a video meeting. If it's a video conference, you do have to record that and keep a record of it for the public to request a copy of, or perhaps you post that online for viewing. For me as a lawyer, this is cutting edge. This is hot news, fresh off the presses. But you'll see the date is really 2019, so it's not that new. It just feels new because I've been doing it a long time. Perhaps some of you have also. But for many of you, you have very few reasons to be concerned about the Texas Court of Criminal Appeals, which is the highest criminal court in Texas. but it did chime in regarding the rare open meetings question, and it found that the former walking quorum provision under the statute was unconstitutional. The statute was 143 of the Open Meetings Act, and it talked about when groups gather in less than a quorum for the purposes of having deliberations outside of meetings. I was involved in the case against the county commissioner and a county judge who were accused of criminally violating the Open Meetings Act for having a meeting outside of county commissioners' chambers, no agenda, no public, no minutes. They were indicted for violating the Open Meetings Act, and I was actually an expert witness for the defense, testifying that the statute was unconstitutional for several reasons. There were other good lawyers from Texas who also testified. The trial judge, a visiting judge, considered it and ultimately dismissed the charges, finding that the statute was unconstitutional. The Court of Criminal Appeals reinstated the indictment, and then ultimately the Court of Criminal Appeals dismissed it and found that the statute was unconstitutionally vague and an infringement of First Amendment rights. Don't worry, almost as soon as the Court of Criminal Appeals invalidated the walking quorum statute, the Texas legislature adopted a new version. So that's what you have here is a new version of Section 143 of the Open Meetings Act, which we casually commonly call daisy chains or walking quorums. What it really is a prohibited series of communications. You can read it for yourself. Just look at 143. I've tried to summarize it for you with a handful of bullets. If you knowingly have one or more communications in a series of communications that involve a group of less than a quorum, and each of those communications takes place outside of a properly posted public meeting, and it's on an issue of public business that's within your jurisdiction, and you know that that series of communications is eventually going to add up to a quorum, you have violated the Texas Open Meetings Act, and it's a criminal prohibition. And so you can imagine you talk to your best friend on the city council about an upcoming vote. Did you know that as soon as they hang up with you, they went and met with a different council member? And after that, the other council member emailed the mayor? At some point, you're counting up the links in this chain to see if it adds up to a quorum. I once knew of a city in West Texas not so long ago where the mayor and two council members met in one office, and then the mayor walked down the hall to a different office to meet with a different council member and a bunch of citizens. And then later, those two, the mayor and a council member, went to a different floor at City Hall to meet with a different group of stakeholders and special interest groups. And all the while, this is being filmed by the local media. And at some point, that series, that chain of communication resulted in a quorum talking about this issue, all of it outside of a meeting. And then you have to worry about the next thing you hear, that being a knock at the door. It's the Texas Rangers, and they're investigating the mayor and city council for violating the Open Meetings Act by having a walking quorum. It seems to me that that probably could have added up to a criminal violation if everyone involved in that chain knew what they were doing and knew what others were doing. Sometimes it's the knowing part that's the hardest part to prove. In that particular case, the mayor and council were never indicted, they never went to trial, they were not convicted. But they were accused of these violations in the traditional print media, the local news channels, and to this day you can Google and find those articles online with those council members being named as violating the statute. You don't want that. And if you follow the advice that I'm giving you in this training session, then perhaps you can avoid criminal sanctions, getting a bad reputation, and just having to deal with the grief of people questioning your behavior unnecessarily. A couple of times today I've mentioned emergencies. Boy, there's no shortage of those here in Texas. We have plenty of reasons to have emergency meetings. But the way the statute words the exception, it's very, very narrow. If you're going to have an emergency meeting, which means you did not post agenda 72 hours in advance, you can do so by posting your agenda just 1 hour in advance. But that is for an emergency or an urgent public necessity. This is something that is an imminent threat to public health, safety, and welfare that you did not see in advance. Now, when you look for examples of that under the statute, you'll even see that the word pandemic is listed, which that meant for many, many years, we knew something like this was possible. I just don't know that we prepared for it as we could have. But if you're faced with one of those emergencies and you must convene your group without waiting for 3 days, you must clearly state what the emergency is on your agenda. Maybe you put up your agenda and it's been up for 72 hours. But after you put it up and the 72-hour clock started to run, something else came up regarding an imminent threat to public health, safety, and welfare that was not reasonably foreseeable. That's okay. You can add an emergency item to your already posted agenda, but it's got to be done at least an hour for the meeting, and you have to clearly state what the emergency is so the public knows. In addition to notifying the public in general about your emergency meeting or your emergency item, you have to notify the media if they have requested to receive such notifications. I'm here to say that even if they didn't request it, let the media know you're doing it. Let's be transparent. That increases trust, and we need trust in order to govern effectively. Maybe they designate it to be notified by phone or fax or email. If you have the ability to do so, please do. Maybe your local reporter gave you their cell phone and said, please text me if you're having an emergency meeting. Having explained to you what an emergency meeting is and adding an emergency item to your agenda, I need to also let you know about the issues of catastrophes. And occasionally we have those in Texas, and they affect our governing body's meetings. If you are engaged in a catastrophe, you're having a horrible weather event or something else, then you are allowed under the law to recess your meeting to the next day, or just delay the meeting to occur within 72 hours of the original time and date. You can do this without having to post a new agenda for your meeting, which is really just a continuation. You are reconvening a meeting you already started. And when does that happen? Earthquakes, fires, floods, snow, rain events. I've been in city council meetings before when a fire chief or chief of police walk in and say, Mayor, if you want to go home tonight, y'all may want to leave now. Otherwise, you may be sheltering in place for several hours. At that point, boom, meeting over and out the door we go. Well, one option is just to repost your meeting for 72 hours later and start over again. Or if it's important, you can just show back up to City Hall, assuming you still have a City Hall, and reconvene and proceed where you left off. That is an option under the law. Having gone through all of this information, I've hit you with a lot, but we're here toward the end of the open meeting segment, and you need to understand that there are some penalties for getting this wrong, and I'm hoping that by going through this training, you're going to avoid having to deal with some of these things. Now, we can talk about jail and we can talk about financial penalties, and we will, but I just have to list first and foremost that the most common, the most realistic form of punishment for violating the Open Meetings Act is that any action you took in violation of the statute is voidable. Meaning if there's a lawsuit later, a judge can void what you did. I've seen some terrible examples of that. One of the worst is in the realm of human resources. I've seen police chiefs be terminated, later sue for wrongful termination, maybe other things, throw in a civil rights violation, a whistleblower claim, and then 1 or 2 years later, a trial court judge fines for the chief of police, finds that the city council violated the Open Meetings Act in firing them, and voids the action, which means your chief of police that you terminated 2 years ago is your employee once again, and you owe them back pay and benefits. Any raises that city employees got over the last 2 years, they get to have a raise also. And if you have insurance or you're covered by the TML risk pool, in my experience, their coverage seldom will pay for that. So you're paying for it out of the general fund. Oh, and by the way, if you hired a new chief of police, that means you have 2. What are you going to do with 2 chiefs of police? That's a pretty big deal. And I wish I was clever enough to make up this scenario. It's not a hypothetical. I've seen that exact thing play out twice. And so if you're going to do it right. Take your time and make sure that you're complying with the Open Meetings Act. Can you imagine rezoning property, approving a development agreement, a purchasing vendor contract, and 2 years later it's voided? Not only what inconvenience does that do to you and the city, imagine the people that you're contracting with and what that does to their lives or their businesses. And so we shouldn't be cutting corners and being clever and sneaky. We need to comply with the statute. That's in the best interest of your citizens and your organization. Some of the other possible violations: having an executive session without a lawful justification for doing so, being in executive session knowing someone's not keeping minutes, there's no certified agenda, unlawful disclosure of the minutes of executive session is punishable. One bit of good news I have for you is if you're in doubt, talk it out with your attorney. Have your attorney write you an email or a memo, or I keep a nice little legal pad in my briefcase. I can write a note and slip it to the mayor saying, I've reviewed the agenda, I'm familiar with the conversation, you are authorized to have this meeting, or you are authorized to go into executive session. Because if you rely on the written advice of your attorney, you have an affirmative defense to prosecution. And if you can produce that and show that your attorney told you the meeting was okay under the law, there's a good chance the county attorney or district attorney is not going to pursue it in the first place. So do reach out to your lawyer when in doubt, but then you need to actually listen to your lawyer, because the violations of the Open Meetings Act can be punishable by up to $500 and or 6 months in jail for each infraction. And that's real jail time. And goodness knows I don't want that for y'all. So wrapping up the open meetings part of our open government training, I'll leave you with a few thoughts that are not strictly under the open meeting statute. The issue of who prepares your agenda, how and when is completely up to you. State law is silent on that part. If you have a local process or procedure, abide by it. If you don't, adopt one. If you don't like the rules, then convene the city council and discuss what the rules should be. There are a few attorney general opinions. They tend to be addressing county commissioners, but that's pretty close. And it says by virtue of being elected to a governing body, you've got a right to put things on the agenda. But the governing body has the right to adopt local rules to steer and guide how that gets done as a practical matter. How you establish a quorum is going to be different on different boards, committees, local governments. Make sure you know what constitutes a quorum in your community. If you're a home rule city, take a look at your charter. That might tell you something you didn't know. Regarding the frequency of meetings, depending on what type of city you are, home rule A, B, C, you might have a statutory duty to meet at least once a month. Maybe you meet twice a month. Is that in your charter, in your ordinance, or is that a local choice? You should know that and do your best to honor that. You can be a wizard at the Open Meetings Act. You've learned everything you need to know from me today. You get a copy of the Attorney General's Office Open Meetings Act Handbook, which is an excellent resource, and you know open meetings in and out. You're still not done. There may be additional notice and meeting or public hearing requirements depending on what you're trying to do. Perhaps you're trying to adopt a tax, implement a new budget, rezone a piece of property, hire or fire someone. You need to actually talk to your city attorney and look at the statute to see if there's additional requirements for notice in a newspaper or giving people a chance to be heard at City Hall. I hate referring to this, but we need to. It is a crime in Texas to purposefully disrupt a public meeting. Governing bodies function at meetings. Meetings are for the governing body first and foremost. So if someone is there distracting you, interrupting you, keeping you from conducting the public's business, you should be able to shh. Hopefully your presiding officer, your mayor, gets them to control themselves. If that doesn't work, perhaps it's a tap on the shoulder by local law enforcement. If that doesn't work, maybe they're going to be shown out of the building. Maybe they're going to be arrested and sent to jail. Now, we don't want to use that just to stifle our critics. That's a violation of the First Amendment, and we value our free speech rights in our democratic institutions. But you got to take care of business. And if someone just will not let you do it, then perhaps they violated the Texas Penal Code and need to be shown the door. That is it for our open meetings presentation and materials, and we will transition to open records. Having gone through the open meetings part of open government, we're now going to flip over to the other side of the coin and deal with open records. And I know this image is not at all what your city secretary's office looks like, but gosh, wouldn't that be fun? As a lawyer, I'd have plenty of work cut out for me to help clean that up. The other half of the open government coin in Texas is the Texas Public Information Act. When I first started practicing law, it was called the Open Records Act. Under the Open Records Act, they were concerned with file cabinets and binders and memos. Now we're talking about cell phones. We're talking about laptops. We're talking about video cameras and iPads. It's the digital technology that we all create constantly and carry with us everywhere that is going to be covered by the statute. Because when you look at the Texas Public Information Act, it's incredibly broad. It covers all data, no matter its format. The Public Information Act covers data that is created by your entity, things that's created for your entity, or things that are given to your entity in order to conduct business. So there can be the memo that a member of your staff wrote for you. It can be the report you hired a consulting firm to create. Or maybe someone needs a permit, a plat, a contract, economic development incentives. And so they create all this data and then they give it over to you in order to get your approval. No matter the source, you are now entrusted and responsible for all of that data. And I don't think at any point in this training session so far I've mentioned email or text messages. Have I? Yeah, I'm dang right annoying about those things. You need to be cautious about emails and text messages because the first thing that any litigator is going to come look for is going to be your emails and text messages. Before they sue your city, before you even know the law firm exists, some name you've never heard of is going to file an open records request trying to get the email first so they can see what you have, what you've been doing, and what's going on behind the scenes. That makes sense. If you're going to go to battle with someone, get their data first. And what concerns me the most about email and text messages versus other kinds of communication is the fact that we're doing so much of it. The increased volume of messages that are just hurling through the cyberspace and the internet. For some reason, we have decided that it's okay to hit send with a lack of formality. We sometimes don't even spell check. We don't have people proofread these messages. We're being impulsive. We're being unfiltered. Does anyone think impulsive and unfiltered is a good way to govern? But yet we're doing it. And those who wish to sue us because we didn't approve the thing or sue us because we did approve the thing, they want our emails. And you can go ahead and lump in social media too. The candid nature with which many people at City Hall are posting on social media platforms is giving the world a lot of ammunition to be used against us. And when we lose lawsuits, that means taxpayers, citizens, voters lose lawsuits. And sometimes we have to give these records over to City Hall's enemies through the Open Records Act before we even have to deal with things like discovery, supervised by a judge. And so I urge you to use caution when you're creating your emails, when you're sending those texts. My clients will tell you, I refuse to practice law by text. I just won't do it. I get a text message urgent from a client. My response is, okay, check your email. And then I switch devices, switch platforms to respond by email because I know how to keep track of email. I know where it's being archived if I'm going to communicate electronically, it's got any substance to it, it's probably going to be an email. How about you? Those of you working in the public realm, whether you're a volunteer, elected, staff, or a consultant, a big thing you need to be aware of is this issue of personal versus public data. If the information is made or transmitted or maintained or received in the course of conducting public business, then the law doesn't care what device created it, which device received it, where it's stored. That's been the law for many years now in Texas, and it's covered by the statute. So your official emails that are exchanged with people to conduct business is going to be subject to this statute, even if it's your device, even if it's your desktop sitting in your guest room at home. And that brings all sorts of interesting scenarios forward. If I, as your city attorney, am transmitting data to you at your home desktop or your home laptop, who else has access to that device? Does your spouse? Are you letting your kids do homework on it? That gets very sensitive when it comes to preserving and protecting public information and confidential data. And also, if you bought a laptop, you bought an iPad, you don't like the phone the city gave you, so you're using those devices to conduct city business, even though you have a city-issued device, the Public Information Act is going to apply to all of that. And so we need to be aware of this, we need to be mindful of it, because it affects not just how we do public business, but how we do our personal business using those devices. I have heard of city officials who have one phone, but two different phone numbers on the same phone. And they'll use one phone number for conducting official public business, telephone or text, and they have a different phone number they use for their personal, family, or friends' communications. You can have more than one email address on your phone or on your laptop. If you have difficulty with that, maybe you need to sit down with the city's IT support and figure out how to make that happen. But the best advice I can give you, whether you use one device or multiple devices, is to try to segregate those messages and bifurcate those communications just for pure record-keeping ease of use. Why is that important? Well, we need the data. We have to respond to it. We're obligated to do so. But for many, many years, if a city secretary, a municipal clerk, sent out an announcement to the entire organization saying, hey, we have an open records request. If you have this data, please get it to me. Maybe they received the data, maybe they didn't. And if you had the data and you as an individual city official refused to hand it over, there was very little that the city could do about it. That clerk did not have the authority to sue you. The city, the entity, is responsible. The individual was not. But the law has changed in Texas. And now, if you're told that there's an open records request and you have responsive data and you don't hand it over, boom! By operation of law, you are magically, automatically turned into a temporary custodian of records, which means now the city can sue you, the state of Texas can sue you for failure to hand over that data in a timely manner. And so you need to keep up with these things. It was bad enough when I was once representing a city in litigation. I got all the city council's emails to and from their official city of email account. And then 6 months later, one of my favorite council members came to me and said, hey, Alan, by the way, I was cleaning out some personal email the other day, and I found a bunch of emails regarding this topic on my personal email. At that point, he had to print them off for me. I had to disclose it to the opposing party and the court and say that we apologize, but we just discovered this data and we're handing it over as soon as we were aware of it. And then I just sort of sat back and braced for impact, right? Waiting for some sort of motion for sanctions. Ultimately, there was no motion for sanctions. The litigation proceeded, and that was okay. But that was a reminder to me that sometimes my clients conduct city business through official channels and through unofficial channels. And what I want to convey to you is the law doesn't care. It's all the same. We are responsible for it. I once had a mayor who conducted business by 2 different email addresses. The way I found out is we got an open records request from a lawyer who happened to be a county judge once upon a time and earned a living representing the newspaper industry. Wow, those are 3 pretty big attributes to the requester in this scenario. And they wanted all email to and from the mayor from any email address. And when I learned that the mayor had email at home that was not going through the city's servers, was not being archived in the city's basement, we had to access that data. Turns out the mayor at the time was in Europe on vacation. Work the problem, find a solution. Turns out the mayor reached their neighbor who had a key to the house and the alarm system. I had to send an assistant city attorney and the city secretary into the mayor's house without the mayor being there to access his home computer and access his email. That was cumbersome. That was awkward. That was embarrassing. That was expensive for the city. That is a real life example of what can happen when you use your home email to conduct business without it going through city servers. Well, I practice in front of many small cities, so I know some of you don't have the resources that large cities have, and maybe using your Gmail or Hotmail or Yahoo account, Outlook account, that's the only option you have. That's fine. But if the city doesn't have access to your email, that means you've got a duty to hand it over. What about text messages? Well, I've sat at a conference once before, sitting up at the big table with very smart lawyers from the Attorney General's office, when they said if you have business-related text messages, you should be taking screenshots on your phone and then emailing or texting those screenshots to the city secretary. Okay, that's a very low-tech way to handle a high-tech problem. Are you going to do the alternative, which is hand over your cell phone to the city secretary, to the city's IT department so they can download your messages? Are you going to just give them the password to access your otherwise personal private email account so we can search through those messages looking for something that's responsive to the open records request? All of those things are possibilities. All those things have happened. Are you going to force us to go the route of turning in a subpoena to your internet provider and try to get your records that way? I know situations where that was done also. Again, time-consuming, expensive, awkward, sometimes controversial. So the simplest and cleanest way you find to manage your communications, the better off the city hall that you are serving. We will find a way to comply with our obligations the best we can, but sometimes some good rules, a little bit of discipline, some housekeeping will make that a little bit easier on everyone involved. When it comes to these requests for data, they can request data in any form that they want to. They can ask for it on paper, digital, CD, thumb drive, to be emailed to them. And if you have the ability to do so, you have a duty to do so. When it comes to the request itself, it can be submitted on any format. Maybe you've got a document, a form that you prefer people to use. Maybe you've got an open government portal on your website and there's an online form you prefer people to fill out. That's good. I highly recommend you have a policy that puts forth those things. In reality, they can request data however they want to. They can come in with a handwritten Post-it note telling you what they want. They can email it to you. They can drop off a 5-page letter. If you have a local policy that says it's got to include certain things like their name, their address, their phone number, and what they want, that's a good idea. Could they just walk in and tell you what they want? Sure. I prefer that you have a policy that says no, they need to put it in writing using their own words. That way, if we ever get into a dispute with the Attorney General or we're in a court case later, we're fighting over the requester's words, not your interpretation of their words. When it comes to the requester's motives, we don't care. It's irrelevant. We don't get to care under the law why they want this data. In fact, it's a violation of the Public Information Act for you to inquire as to their motives. So don't do it. And when I've received a nasty gram from the Attorney General's office threatening my client because they unlawfully requested a requester tell us why they want the data, I go and look into the situation and uniformly find out my client was just trying to help. Just trying to help them get what they want faster, cheaper, and easier. And they thought asking some questions would help the requester out. Yeah, well, sometimes no good deed goes unpunished. Remember, we're not allowed to inquire as to why they want it. I've helped clients process requests from lawyers they've never heard of that live hundreds of miles away from City Hall. And we'll spend months and months responding to the request because it's voluminous and never ever find out what the requester was doing. No idea why they wanted that. They were searching for something. They cast a very broad net and went fishing. And I guess they didn't find what they were looking for. Or perhaps they found that, yep, the city's been doing things right all along. No need to bring some sort of complaint or some sort of challenge. But we don't get to ask what the requester's motives are. We get to just process their data request in a timely manner. Now, if you're looking at their open records request and you don't understand it, you don't know what they're looking for, or you think that responding is going to be very expensive and time consuming, you can ask them to clarify their request. You can ask them to narrow their request, and you can do so in writing. And when you do so, that stops the clock. And the clock is a very important part of the Public Information Act. We'll spend some time at upcoming slides talking about the details of deadlines. But if you don't understand what they're seeking, or you think it could take a lot of time and money, maybe you want to send them a letter asking them to narrow it. For example, I've helped clients write a letter saying, if I understand what you're looking for, it's going to take us 6 months to compile the data, and we're going to send you a bill for $12,000. Boom. They had no trouble narrowing the scope of what they were looking for. Because sometimes they throw around a phrase, I don't know where it came from, but so many requesters have picked up on it. They're seeking any and all information regarding fill in the blank. Any and all information might be a lot of data. And so when you tell them it'll take you 3 weeks and cost them $500, they may come back and say, no. I just heard you had a report on this topic. Oh, okay. Yeah, we have a copy of that. We'll give it to you tomorrow. We'll give it to you for free. Okay, that's good public service. And that's sometimes the result of getting them to clarify or narrow. But sometimes you have to be prepared for them to say, no, I decline this opportunity to clarify and narrow. I once had a lawyer tell me, Alan, I don't know what I want because I don't know what you got. All right, we'll spend the time going through this process and we'll send an invoice to your client for the bill. And we're going to provide you an estimate up front of what those costs are going to be. But once they tell you to go ahead, I don't want to clarify, or they do clean up their request a little bit, the clock starts over again. So don't use this as a delay tactic. That would be wrong. But do understand you don't have to spin your wheels and over-provide or under-provide if you truly don't understand what they are looking for. Now, when it comes to responding, you must make sure that you are uniform in your responses. You can't pick your favorite citizens or your favorite reporters, and you quickly give free copies of data to some, but you delay and charge a fortune for others. You must treat everybody uniformly. Now, when it comes to the timing of when and how you respond to an open records request, when must you respond to that request? Many of you are thinking 10 days. You've heard the 10-day thing, you're not quite sure what it means, you think it's 10 days, and you're mostly right. What the statute says is we must respond promptly. What does promptly mean? Originally, I didn't know. When the legislature adopted promptly, it led a lot of us guessing. But don't worry, they came back 2 years later and defined the word promptly to mean as soon as possible under the circumstances. Okay, so maybe promptly means you respond same day if you've got copies of it sitting on your desk. same day if all you have to do is attach it to an email and hit send. But maybe it's going to take you a week. Maybe it's going to take you a month. Maybe compiling it from all the different sources is going to take you 6 months. It's going to depend on the circumstances. But the 10-day rule is in fact a rule. And what it says is that within 10 business days, not calendar days, but within 10 business days of receiving the request, you're going to do one of three things. You're either going to give them the data, you're going to tell them when to expect to receive the data, or you're going to go to the Attorney General's office and seek clarification from the AG about whether you can or must release the data. You must do something within those 10 business days. Now, in calculating business days, you can exclude state, national, or local holidays. So if your city observes a holiday that the state and federal government doesn't do, you're closed even though maybe the banks are open, that's okay as long as it is in writing. But there's a limitation on how many of your local days off you can have in a year. The requester might be seeking copies of data. They might just want to sneak a peek. So if they are only asking to look at the data, you have a duty to give it to them so they can inspect it. Now, is that looking at a screen? Is it copies? If it's fragile data, maybe it's antique documents, it's the only version of something you have, you may need to have someone sitting in the room with them to make sure they're not vandalizing the document. They cannot be intimidating or imposing. The person has a right to view this. Maybe they have a portable scanner. Maybe the requester just wants to take photos using their smartphone. That's acceptable too. But if they want copies, they can request paper copies, electronic copies, and you have the ability to charge them certain costs for that based on the schedule of fees that the Attorney General's office publishes online. That schedule changes frequently, so looking at it once a year at budget time is not enough. Your records administrator, your city secretary, municipal clerk, maybe it's a secretary in the police department, fire department, you need to be looking at that schedule of fees on a regular basis. I've mentioned that we have a broad duty to disclose an array of data to anyone who requests it, any member of the public. Doesn't matter if it's a citizen, a business owner, a voter, a resident, a homeowner. Anyone who requests data has a right to it, and we have to process that request under the Texas Public Information Act. And we have to do so within the series of deadlines that I've given you. But there are a lot of exceptions, and I can't possibly cover them all today, but I'll highlight for you some of the ones that we see most frequently. The first one, which as a lawyer, I look at this one a lot. Is it confidential? Is it privileged? Things that are confidential by law means some statute somewhere makes it confidential. Could be in the family code, could be in the real estate code, could be in the local government code. If it's privileged, it's protected because it comes from your lawyer or was sent to your lawyer. Or maybe there's a different privilege out there. Doctor-patient privilege, pastor-penitent privilege. There are different privileges out there. There's also a common law sense of confidentiality. If releasing it would shock the conscience, then we might be able to withhold it as confidential under common law, being bootstrapped into the Texas Public Information Act. There are certain exceptions for legal matters, including litigation, ongoing lawsuits, anticipated lawsuits. Maybe your police department is actively involved in a criminal investigation. Maybe your fire chief is involved in an active arson investigation. If disclosing that data would interfere with the investigation, then we have the ability to withhold the data while those investigations are ongoing. I mentioned buying and selling real estate under the Open Meetings Act. Well, we have a similar exception under the Public Information Act that would allow us to withhold information regarding those transactions while they're ongoing. Once the transaction has been closed, then a lot of that data is going to become public information that people can request copies of. So it doesn't say exclusively ours forever. We talked about economic development under open meetings. Now we get to talk about it under open records. Because if you are negotiating with a business to come to your town, stay in town, expand their offerings, maybe have a larger workforce, and they get some taxes reimbursed to them, some cash, utilities, whatever, the documents regarding those transactions can be kept away from the public while you're negotiating that deal. But if the deal falls through or you finally sign it, then a lot of that data is going to see the light of day. Now, if the material is from your attorney or to your attorney, that might still be privileged and thus confidential. So you really have to sort through the material before you decide whether to release it. Security measures, oddly, there's no blanket exception for security measures under the Public Information Act like there is under the Open Meetings Act. We're limited to the Texas Utilities Code that says public infrastructure like water, wastewater treatment plant, gas, electric generating or transmission facilities. If you have security measures regarding those bits of infrastructure, you can withhold that data from the public. And in this age of security concerns regarding terrorism and that sort of thing, the exception makes sense. Now, if you come across anything dealing with juveniles, victims of crime, medical or health data, then ding, 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 I'm hoping bells and whistles are going off in your head that you're very, very careful with how you handle that data, and you might not want to disclose it until you've at least run it by your city attorney. Sometimes we at City Hall come into contact with third-party financial data. Maybe you are looking into doing an exclusive franchise for solid waste collection, transportation, and disposal. Maybe you're going into a deal with a hotel. Well, it's possible that in the course of negotiating those deals, or you've done a request for proposals, you've come across some trade secrets, some sensitive financial data. Well, there can be punishments for releasing that data. There can be punishments for not releasing that data, depending on the circumstances. So you want to scrutinize that type of material under the Public Information Act, and it's a good idea, again, to consult with your attorney regarding those things. Now, fortunately, in Texas, we have an exception that's referred to under the statute as agency memoranda. The courts call it the deliberative process privilege. What does that mean? It means that in Texas, the legislative body, city council, county commissioners court, those sorts of groups, have the ability to keep certain data to themselves while they are discussing a legislative decision they have to make. And if releasing all that data to the public would interfere with their ability to kick it around, maybe do some horse trading, some give and take, and make that decision, well, then we get to withhold it. That's the deliberative process privilege. Maybe a memo from the city manager or a report from the finance director. Those could be a couple of examples. So if you label it agency memoranda, confidential, internal only, draft, those sorts of things might help you, first of all, safeguard the data, and second of all, withhold it from the public when it's requested. And you can go to the Attorney General's office and make an argument about the need to withhold it. I've become a big fan in recent years of all the cool tools that technology provides us to help us label our documents, and by labeling, hopefully protect. So clients who receive documents from me often see draft, confidential, privileged, in the header, in the footer, maybe diagonal across it in the watermark. All of those things are meant to signal to the recipient that this isn't just any old communication. This is data that we might not want to see printed in the newspaper or posted on Facebook. So let's treat it carefully. And at least we might be able to withhold it for a period of time. We want to be transparent with our citizens, but maybe it's not in the taxpayer's interest for everyone to see everything all the time. We need to be a little bit more judicious with it. Now, just because we call something a draft doesn't mean we get to withhold it forever. There's a court case out of the Dallas-Fort Worth area where a city council was considering firing a finance director, and the city manager wrote a report about the finance department and the director, and the manager did a great job of labeling it draft. And so when later the finance director was in fact fired, here comes the Dallas Morning News looking for a copy of that report. And the city said, "Not so fast, reporters. This is a draft, and we're able to withhold it under the Open Records Act as agency memoranda." Well, when it went to trial, there was testimony that while it was labeled draft, and perhaps it wasn't a finished, completed document, the city council and the city manager absolutely used that document when making the decision to terminate that finance director. So the way they used it determined whether it had to be accessed or not. Labeling it is a nice reminder, but it's not going to be dispositive. If you finally use something in making your decision, be prepared for that to be released at some point in time. Throughout this presentation, I've mentioned the Attorney General's office frequently. Under the statute, the Open Records Division of the Attorney General's office has a great deal of responsibility. Yes, they review curriculum like today's training, and in this case, they signed off on it after making me make a few tweaks to it. That is part of their job. But the part that affects most of you most of the time is there's very few exceptions in the Public Information Act that you can use automatically without having to go to the Attorney General's office. A good example would be Social Security number, driver's license, vehicle identification number. You can get your big flat marker and black out those things without having to go to the Attorney General's office for permission. But most of the exceptions, including the list I just showed you, are things that you must raise before the Attorney General and give them a chance to give you an opinion. So within those 10 business days that I mentioned earlier, if you want to withhold data, you probably need to go to the Attorney General, give them a copy of the request, and tell them what justification you have for withholding the data. You've got to do that within 10 business days, and you've got to let the requester know that you're doing it. Then, within 15 business days of receiving the request, you have to brief the Attorney General. You have to write them a letter arguing your point. What justifications apply to this? What's your basis for withholding this? Why do you think you cannot release this to the public? The requester gets to do the exact same thing, and then the Attorney General's office gets to weigh those and decide what to do by issuing you a letter ruling, which is usually an informal opinion. They usually have 45 days within which to do that. They often take less, but if they need more time, they can give themselves an additional 10 days. If you don't like what the AG's opinion has to say, and you want to challenge the Attorney General, there is no internal appeal. There is no formal process to seek reconsideration. Instead, your only remedy is to challenge the Attorney General's opinion by suing the Attorney General in Travis County, which is Austin. And at that point, the Attorney General's office may abandon their opinion, or there may be a trial that you have to go through to prove that. The AG's office does other things that are useful and worthwhile. I mentioned the list of fees, what you can charge for a USB thumb drive, what you can charge for a copy. Those sorts of things are maintained online and change frequently. If you do not comply with the statute and someone has filed a request, they may go to the Attorney General's office to complain about you, which means you may be getting phone calls or letters from the AG asking you to comply. And most people do at that point if somehow it had fallen through the cracks. If you fail to apply, then the Attorney General's office might seek out the local district attorney or county attorney, and there is an enforcement function at the AG's office where they'll provide support for bringing charges against you for failure to comply. Just like I mentioned the Open Meetings Handbook earlier, there's an Open Records Handbook, the Public Information Handbook published by the Attorney General's office. It's free, it's online, it's an excellent resource, and I commend it to you as something you want to be familiar with. I think it's worth underscoring this several times because you come into contact with so much sensitive data, financial data, health data. Let's face it, we have EMS, we have fire, we have police. We come into people's lives on the worst day of their lives. Well, in collecting all that data, we're responsible for safeguarding it. The financial data, whether it's external to companies that we do business with or internal, what are our employees doing with their investments and their retirement accounts and those sorts of things? You may want to store that data separately. I've been at a trial under the Public Information Act where questions were asked of the city attorney. Where did the memo come from? Who wrote it? Where did you store it? Who had access to the filing cabinet? Was the filing cabinet locked? Those sorts of things may come out if you ever actually go to trial on this, and you want to have good answers. And with electronic data, we get so careless, we get so sloppy, and all of a sudden, confidential data can get passed around to people, and it may have the effect of blowing the privilege or blowing the confidentiality of it. So I want to urge you to handle it with care. Be cautious who you share it with, and try to restrict data. Being loose with this data could hurt you, it could hurt the community, it could hurt your city, and I don't want that to happen for you. When it comes to enforcement, there can be civil and criminal remedies. A declaratory judgment or injunctive action brought against you that gets a court order. If you destroy data after an open records request has come in, there can be a different set of fines and penalties separate and apart from the Records Retention Act, under which we all adopt our records retention schedules. Distributing or misusing confidential information can come with its own set of criminal penalties, and failure to provide data when you had a duty to do so can result in up to 6 months in jail or $1,000 per violation, or both. It's rare for there to be prosecutions under the Public Information Act, but they do happen, and that's something you want to avoid. So I hope you have the infrastructure in your organization, the people, the equipment, and the procedures to handle these requests in a timely manner. And I hope you make training an ongoing part of what your city does. You've watched this video. Hopefully you learned a thing or two. And I hope you take this information and use it to teach those of you at City Hall that deal with these records, and your boards, your commissions, your employees, your city council, so they can be good shepherds of this process and good stewards of this data. So I'll finish where I began. I know it's a lot of material, but I gave you the PowerPoint. You've got a copy of this that you can go back and take a look at when you registered for this. And on all of my slides, I've given you a legal citation to my sources. It's never been easier than it is now to go online for free and find the law. And so if you're curious about one of my slides or a remark that I made, if you just look at those blue citations on your slides, you'll be able to pull up that data yourself, and maybe it'll remind you of something that I covered in the video. But I know for a lot of things, it's in one ear, out the other. So in terms of the 6 things I was hoping you'd remember, I hope you remember that all of the data you come into contact with is probably public data, which means it's covered by the Public Information Act. And we have a duty to archive it and then provide it to people upon request. I hope you build those filters deep inside where you remember to think before you create. Am I conveying this data in the right way, the right form? Should this be a conversation in person? Should it be an email instead of a text? Maybe it shouldn't be an email at all. It should be a memo that gets printed on city letterhead. Someone proofreads it and you actually sign your name next to it because the contents are that important. I hope you hold on to the fact that private devices can hold public information. The courts no longer care who paid for the device, the internet service. They care about the data, wherever it's created, wherever it resides. And therefore, you've got to be cautious about email, text messages, and social media posts. Those can all be public information, and you can violate the Open Meetings Act by text. You can have an illegal meeting on nextdoor.com or Facebook. by a quorum of your body communicating about public business outside of a meeting. And not only have you violated open meetings, people can get evidence to use against you through open records. Assume that all gatherings of your board, your committee, your commission, your city council, all those gatherings are a meeting, particularly if there's going to be a quorum there. And if there's a meeting, then you have to follow the rules regarding the Open Meetings Act. Post an agenda, allow the public to come and speak, keep minutes. And then finally, be aware of the walking quorum. Be aware of your chit chat, whether it's by text or in person or by phone with other members of your board or commission. Because if it's outside of a meeting, it's about public business and it adds up to a quorum, then you might have violated Section 143 of the statute. That's a daisy chain walking quorum violation, and you may be subject to criminal investigation, and that's something you should try to avoid. So I thank you for your time and attention. I hope you found this material worthwhile, and it makes you a better public servant, less likely to get in trouble. In this day and age, government is far more transparent and open than it's ever been. And because of that, these two statutes, open meetings and open records, are more important than ever. And if you're going to choose to serve your community on the municipal side of the equation, then you've got to be familiar with these and use them every day. And we hope this material helped. Thank you very much. Best of luck to you.